So, the guideline about the Protection of Human Rights Act 1993, as amended by the Protection of Human Rights Amendment Act 2019, number 19 of 2019, with effect from 2/8/2019, by notification number SO 2756A, date 1/8/2019, reads as follows. It has following contents, like the chapter 1 narrates about the preliminary details about short title, extent and commencement. Then point 2 details about definition. Chapter 2 tells about the National Human Rights Commission. Number 3, constitution of a National Human Rights Commission, appointment of chairperson and other members, resignation and removal of chairperson and members, term of office of chairperson and members, member to act as chairperson or to discharge his functions in certain circumstances, terms and conditions of service of chairperson and members, vacancies, etc., not to invalidate the proceedings of the commission, procedure to be regulated by the commission, officers and other staffs of the commission. Chapter 3 deals about functions and powers of the commission, like functions of the commission, powers relating to inquiries, investigations, statement made by person to the commission, persons likely to be prejudicially affected to be heard. Chapter 4 deals about procedure, like inquiry into complaints, steps during and after inquiry, procedure with respect to armed forces, annual and special report of the commission. Chapter 5 deals about State Human Rights Commission, like constitution of State Human Rights Commission, appointment of chairperson and members of State Commission, resignation and removal of chairperson or a member of the State Commission, terms of office of chairperson and members of the State Commission, then members to act as chairperson or to discharge his functions in certain circumstances, terms and conditions of service of chairperson and members of State Commission, officers and other staff of the State Commission, annual and special reports of State Commission, application of certain provisions relating to National Human Rights Commission to State Commission. Chapter 6 deals about human rights courts, like human rights courts, special public prosecutors. Chapter 7 deals about finance, accounts and audits, like grants by the central government, grants by the state government, accounts and audits, accounts and audit of State Commission. Chapter 8 deals about miscellaneous subjects matter related to the acts as matters not subject to jurisdiction of the commission, constitution of special investigation teams, protection of action taken in good faith, members and officers to be public servants, power of central government to make rules, power to make rules retrospectively, power of commission to make regulations, power of state government to make rules, power to remove difficulties, repeal and savings. Then the Protection of Human Rights Act 1993, number 10 of 1994, dated 8 January 1994, reads as follows. An act to provide for the constitution of National Human Rights Commission, State Human Rights Commission in states and human rights courts for better protection of human rights and for matter connected herewith or incidental thereto. Like this act is framed with purpose to protect the rights of the people, be it enacted by Parliament in the 44th year of the Republic of India as follows. Like chapter 1 reads as, the preliminary details are stated as below. The short title, extent and commencement. Like this act may be called the Protection of Human Rights Act 1993. It extends to the whole of India, and it shall be deemed to have come into force on 28th day of September 1993. Definitions. Number 1, like in this act, unless the context otherwise requires: A. Armed forces means the naval, military and air forces, and includes any other armed forces of the Union. Chairperson means the chairperson of the commission or of a state commission, as the case may be. And para BA reads as Chief Commissioner, means the Chief Commissioner for persons with disabilities, referred to in subsection 1 of section 74 of the Rights of Persons with Disabilities Act 2016, 49 of 2016. The Commission means the National Human Rights Commission constituted under section 3. Para D states that human rights means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international conventions and enforceable by courts in India. Number E states Human Rights Court means the Human Rights Court is specified under section 30. Para F deals international conventions means the International Convention on Civil and Political Rights and the International Convention on Economic, Social and Cultural Rights, adopted by the General Assembly of the United Nations on the 16 December 1996, and such other convent or convention adopted by the General Assembly of the United Nations as the central government may be notified especially. Here are some footnotes like number 1 with reference to like here are 3 footnotes like received the assent of the President on the 8th January 1994 and the Act published in the Gazette of India Extraordinary Part 2 Section 1 dated 10 January 1994. Proviso omitted by the Jammu and Kashmir Reorganization Act 2019 34 of 2019 Section 95, 96 and 5th Schedule Table 1 provides so before omission stood as under, like provided that it shall apply to the state of Jammu and Kashmir only insofar as it pertains to the matters relatable to any of the entries enumerated in List 1 or List 3 in the 7th Schedule of the Constitution as applicable to the state. And there are some insertions or substitution. Para G reads that the member means a member of the commission or of the state commission as the case may be. Para GA reads like National Commission for Backward Classes means the National Commission for Backward Classes constituted under Section 3 of the National Commission for Backward Classes Act 1993, 27 of 1993. H reads like National Commission for Minorities means the National Commission for Minorities constituted under Section 3 of the National Commission for Minorities Act 1992, para 19 of 1992. Here, National Commission for Protection of Child Rights means the National Commission for Protection of Child Rights constituted under Section 3 of the Commission for Protection of Child Rights Act 2005, 4 of 2006. Para I means National Commission for the Scheduled Caste means the National Commission for the Scheduled Caste referred to in Article 338 of the Constitution. Then National Commission for the Scheduled Tribes means the National Commission for the Scheduled Tribes referred to in Article 338A of the Constitution. Para J means National Commission for Women means the National Commission for Women constituted under Section 3 of the National Commission for Women Act 1990, 20 of 1990. Para K reads notification means a notification published in the official gazette. Para L means prescribed by rules made under this action. Para M means public servants shall have the meaning assigned to it in Section 21 of the Indian Penal Code 45 of 1860. Para N states the State Commission means a State Human Rights Commission constituted under Section 21. Then the second details as any reference in this act to a law which is not in force in the state or Jammu of Kashmir shall in relation to the state to be constructed as a reference to a corresponding law if any in force in the state. But the related amendments could be seen in the forthcoming documents that ensures after um, omission of 370 and other amendments brought by the ruling government, there might be certain what we can say change in this context also. Chapter 2 refers about the National Human Rights Commission. Constitution of National Human Rights Commission. Number 1. The central government shall constitute a body to be known as the National Human Rights Commission. Why? To exercise the powers conferred upon and to perform the functions assigned to it under this act. So the commission is constituted with purpose to implement the frameworks and provisions provided by the this charter. Like the commission shall constitute of a a chairperson who has been a Chief Justice of India or a judge of the Supreme Court. B. One member who is or has been a judge of the Supreme Court. C. One member who is or has been the Chief Justice of a High Court. D. Three members, out of which at least one shall be a woman, to be appointed from amongst persons having knowledge of or practical experience in matters relating to human rights. Like those people could be appointed, like three members. Among these, at least one should be women, and these three members could ensure that they carry practical knowledge, experience in matter relating to human rights. Then para 3 states the chairperson of the National Commission for Backward Class, the National Commission for Minorities, the National Commission for Protection of Child Rights, the National Commission for the Scheduled Caste, the National Commission for the Scheduled Tribes, the National Commission for Women, and the Chief Commissioner for Persons with Disabilities shall be deemed to be members of the Commission for the discharge of functions as specified in Clause B to J of Section 12. Another provisions are as follows, like there shall be a Secretary General who shall be the Chief Executive Officer of the Commission and shall subject to control of the chairperson, exercise all administrative and financial powers, expect judicial functions and the powers to make regulations under Section 40B. So if we'll narrate that, a Secretary General will be appointed who will function as a Chief Executive Officer of the Commission, and the chairperson, like the Secretary General, will control the chairperson, exercise all administrative and financial powers, matters associated with functioning of the commission and regulation of the financial affairs, like except judicial functions and the power to make regulations under Section 40B. So the Secretary General is empowered with the act to make regulations, but they are not entitled or not empowered for any judicial functionings. The headquarters of the commission shall be at Delhi, and the commission may, with the previous approval of the central government, establish offices at other places in India. Then para 4 states appointment of the chairperson and other members. Like the chairperson and the members shall be appointed by the president by warrant under his hand and seal, provided that every appointment under this subsection shall be made after obtaining the recommendations of a committee consisting of the Prime Minister is the chairperson of the NHRC, Speaker of the House of the People, a member like a minister in charge of the Ministry of Home Affairs in the Government of India, member. So in this context, Prime Minister Narendra Modi is the chairperson of the commission. Then Amit Shah is the member of the said commission. Leaders of the opposition in the House of the People, like Mallikarjun Kharge is now representing as leader of the opposition in the House, so he is also a distinguished member of the respected commission. Leader of the opposition in the Council of States. Then, but this seat is, I think, vacant so far in Rajya Sabha. There are related updates that need to be updated. Then, Deputy Chairman of the Council of States will be a member of the said commission. Provided further that no sitting judge of the Supreme Court or sitting Chief Judge of a High Court shall be appointed except after constitution with the Chief Justice of India. Para 2 state that no appointment of a chairperson or a member shall be invalid merely by reason of any vacancy of any member in the committee referred to in the first provision to subsection. Para 5 mentions about resignations and removal of chairperson and members. Like the chairperson or any member may be notice in writing under his hand addressed to the President of India, resign his offices. Then the subject to the provisions of subsection 3, the chairperson or any member shall only be removed from his office by order of the President of India or the ground of proved misbehavior or incapacity after the Supreme Court or reference being made to it by the President has on inquiry held in accordance with the procedure prescribed in that behalf by the Supreme Court reported that the chairperson or the member, as the case may be, out on any such ground to be removed. Let us discuss this point. Like the subject to the provisions of subsection 3, the chairperson or any member shall only be removed from his office by the order of the President of India on the ground of proved misbehavior or incapacity after the Supreme Court on reference being made to it by the President. Like if a Supreme Court refers or submits confidential report about the chairperson or any members to the President of India, then President of India could remove the chairperson or respective member on that behalf. But there are factors associated with proving the majority in the House. Then there are related factors like how the dynamics among the executive legislative is being regulated, because there are associated role of Supreme Court also. Like Supreme Court could conduct concurrent monitoring or what we can say appraisal of the functioning of the what we can say commission. So if Supreme Court submits report to the President of India about proved misbehavior or incapacity, then President of India could remove the chairperson or any member of the NHRC on the basis of the submitted report that referred member are what we can say alleged of misbehavior or incapacity to look after the commission. So the reference will be made by Supreme Court to the President about any such what we can say discharge of the persons. Has an inquiry held in accordance with the procedure prescribed in the behalf by the Supreme Court. So there are certain procedures that is being prescribed by Supreme Court, and the due process need to be followed about any as such appraisal of the functioning of the commission. And reported that the chairperson or the member, as the case may be, out on any such ground to be removed. Number 3. Now, withstanding anything in subsection 2, the President may, by order, remove from office the chairperson or any member if the chairperson or such member, as the case may be. The related matter forwarded by Supreme Court is either adjourned as insolvent. So, what could be the basis for removal of any member or chairperson from the referred commission? The President could execute his power in case there are certain clauses associated with such regulations with functioning of the commission, or what we can say a retention of the office by the office bearer or their removal from the said post. Like if the case is adjourned as insolvent, like they are unable to resolve the matters related with human rights, then or engage during his term of office in any paid employment outside the duties of his office, like the if member is found that they are performing certain other duties instead of functioning for the said commission, then it could be considered as a basis for taking HR related actions against the member. Like if the member is unfit to continue in office by reason or infirmity of mind or body, like if there are certain proved reasons to prove that there are reasons of infirmity or mind or body of the said member, or is of unsound mind and stains, so declared by a competent courts, right? Then the next one is convicted and sentenced to imprisonment of an offense which, in the opinion of the president, involves moral turpitude. So let's think about this term, turpitude. Moral turpitude means moral turpitudes, like a depraved or wicked behavior or character, like moral turpitude it is termed as. So in this context, if we'll see, so there are, if any, as such, what we can say, evidential proof to prove that the referred member is like convicted and sentenced to imprisonment of an offense which in the office of the president involves moral turpitude. Then there are related actions which includes like HR related procedures that need to be followed. Let's think about the other things like terms of the office of the chairperson and members. Like a person appointed as chairperson shall hold office for a term of 3 years from the date on which he enters upon his office or until he attains the age of 70 years, whichever is either, and shall be eligible for reappointment. Para 2 states that a person appointed as member shall hold office for a term of 3 years from the date on which he enters upon his office and shall be eligible for reappointment. There are certain clauses associated with the reappointments that we will refer further in the provided footnotes. And it provides that the no member shall hold office after he attains the age of 70 years. Para 3 states that on ceasing to hold office, a chairperson or a member shall be ineligible for further employment under the Government of India or under the government of any states. Para 7 states that member to act as chairperson or to discharge his functions in certain circumstances, like the number 1 subpara of the said para states that in the event of the occurrence of any vacancy in the office of the chairperson or by reason of his death, resignation, or otherwise, the president may be, by notification, authorize one of the members to act as the chairperson until the appointment of a new chairperson to fill such vacancy. Subpara 2 states that when the chairperson is unable to discharge his functions owing to absence or leave or otherwise, such one of the members as the president may, by notification, authorize in this behalf, shall discharge the functions of the chairperson until the date on which the chairperson resumes his duties. Para 8 states the terms and conditions of service of chairperson and members, like the salaries and allowance payable to, and the other terms of conditions of service of the chairperson and members shall be such as may be prescribed, provided that neither the salary and allowance nor the other terms and conditions of service of the chairperson or a member shall be varied to his disadvantage after his appointment. Para 9 states that vacancies, etc., are not to invalidate the proceedings of the commission. No act or proceedings of the commission shall be questioned or shall be invalidated merely on the ground of existence of any vacancy or defect in the constitution of the commission. Para 10 states that procedure to be regulated by the commission, like the commission shall meet any such at such time and place as the chairperson may think fit. Para 2 states that, subject to the provisions of this Act and the rules made thereunder, the Commission shall have the power to lay down by regulations in its own proceeding. Subpara 3 states that all orders and decisions of the Commission shall be authenticated by the Secretary General or any other officer of the Commission duly authorized by the chairperson in this behalf. 11 states that officers and the other staff of the commission, like the central government, shall make available to the commission. Subpara 1. An officer of the rank of the secretary to the government of India, who shall be Secretary General of the commission. And para B. Such police and investigative staff under an officer not below the rank of a Director General of Police and such other officers and staffs as may be necessary for the efficient performance of the function of the commission. Like the para 11 states about officers and other staff of the commission, like the central government shall make available to the commission, like if commission aspires that they need to extend their forces, like their manpower, then the central government shall make available to the commission following ranked or eligible candidates to the commission. A. An officer of the rank of the Secretary to the Government of India, who shall be the Secretary General of the Commission. And B. Such police and investigative staff under an officer not below the rank of a Director General of Police and such other officers and staff as may be necessary for the efficient performance of the functions of the Commission. Number 2. Subject to such rules as may be made by the central government in this behalf, the Commission may appoint such other administrative, technical, and scientific staff as it may consider necessary. Para 3 states that the salaries, allowance, and conditions of the service of the officer and other staffs appointed under subsection 2 shall be such as may be prescribed. Chapter 3 Functions and Power of the Commission states that, like functions of the Commission shall perform all or any of the following functions, namely A. Inquire suo motu or on a petition presented to it by a victim or any person on his behalf, or on a direction or order of any court into complaint of violation of human rights or abatement thereof. Let's see this. Abatement means the act of helping or encouraging someone to do something wrong or illegal. Such acts will be treated as abatement to be proud. It will be wrong to treat the offense of abatement lightly. So there were factors related with violations of human rights as I have reported to the respective commission. Like there were violations of the human right of the people due to this COVID-19. There were negligence in the prevention of such violations by a public servant due to the lack of knowledge about the related modus operandi or the technical know-how for like carriers, and it's a related control by enforcement of community prevention measures. Paravi refers about intervene in any proceedings involving any allegations of violations of human rights pending before a court with the approval of such court. Para C states that visit, notwithstanding anything contained in any other law for the time being in force, like any jail or other institution under the control of the state government, where persons are detained or lodged for purpose of treatment, like if they follow, like visit, notwithstanding anything contained in any other law for the time being in force, any jail or other institution under the control of the state government, where persons are detained or lodged for purpose of treatment, reformation or protection for the study of the living conditions of the inmates thereof, and make recommendations thereon to the government. Like review the safeguards provided by or under the constitution or any law for the time being in force for the protection of human rights, and recommended measures for their effective implementation. Like they should review the safeguards provided by or other under the constitution or any law for the time being in force for the protection of human rights, and recommend measures for their effective implementation. Next paragraph states that review the factors including act of terrorism that inhibits the enjoyment of human rights, and recommend appropriate remedial measures. Like the factors should be reviewed if there are certain facts associated with including the act of terrorism that inhibits the enjoyment of human rights, whether the human rights were violated or whether practice were meant to resolve the problems of the society or how people are framing it, for the sake of their protections. If there are certain allegations of any such like terrorism or anything, if some person bearing office will term that you are terrorist or he is terrorist, it doesn't mean that person should be convicted. There are certain factors that need to be followed, like a review of the factors including act on terrorism, on which basis the person is being referred into this matter, because this rule is specific, impossible into the context of the Jammu and Kashmir, that how they are identified or how they are marked and they are being treated accordingly. That inhibits the enjoyment of human rights, if there are certain factors of allegations of such kind of heinous acts, then their human rights will be inhibited, and under the shadow of such inhibition there might be further violations of the human rights of the in-laws of the people, and recommend appropriate remedial measures so that they can manifest the uh, proper obedience of the due process of law enforcement. Study treaties and other international instruments on human rights and make recommendations for their effective implementations. These are the one of the functionings of the organization, the treaties and other international instruments of human rights need to be followed, and the NHRC should make recommendations for their effective implementation. NHRC could undertake and promote research in the field of human rights, that what are the aspects related with violations of the human rights of the people and how their rights could be protected. NHRC could spread human rights literacy among various sections of the society and promote awareness of the safeguards available for the protection of these rights through publication, the media, seminars, and other available means. NHRC could encourage the efforts of non-government organization and institution working in the field of human rights. NHRC could encourage the effect of non-government organization and institution working in the field of human rights. NHRC could impose any such other functions as it may consider necessary for the promotion of human rights. Then powers relating to inquiries. Para 1. The Commission shall, while inquiring into complaints under this Act, have all the powers of a civil court, trying a suit under the Code of Civil Procedure 1908, and in particular in respect of the following matters, namely: 1. Summoning and enforcing the attendance of witness and examining them on oath. If I have submitted some reports related with violations of human rights during this period of pandemic, then they need to be witnessed. Like the submitted testimonies need to be reviewed, and if I am a person, I appeared or submitted my report as a witness of the said pandemic, then I need to be notified so that the submitted oath could be examined. Then the discovery and production of any documents, the related testimonies, receiving evidence on affidavits, re-questioning any public record or copy thereof from any court or office, or issuing commissions for the examination of witness or documents or any other matter which may be prescribed. Then the Commission shall have power to require any person, subject to any privilege which may be claimed by that person under any law for the time being in force, to furnish information on such points or matters as in the opinion of the Commission may be useful for or relevant to the subject matter of the inquiry, and any person so required shall be deemed to be legally bound to furnish such information within the meaning of Section 176 and Section 127 of the Indian Penal Code. So the Commission shall have power to require any person, subject to any privilege which may be claimed by that person under any law for the time being in force, to furnish information on such points or matters as in the opinion of the Commission may be useful for or relevant to the subject matter of the inquiry, and any person so required shall be deemed to be legally bound to furnish such information within the meaning of Section 176 and Section 127 of Indian Penal Code. So the related sections need to be further reviewed. Number 3, the commission or any other office not below the rank of a gazetted officer, especially authorized in this behalf by the commission, may enter any building or place where the commission has reasons to believe that any document relating to the subject matter of the inquiry may be found, and may seize any such document or take extracts or copies therefrom, subject to the provisions of Section 100 of the Code of Criminal Procedure 1973, insofar as it may be applicable. Para 4 states that the commission shall be deemed to be a civil court, and when any offense as is described in Section 175, Section 178, Section 179, Section 180 or Section 228 of the Indian Penal Code is committed in the view or presence of the commission may, after recording the facts constituting the offense and the statement of the accused as provided for in the Code of Criminal Procedure 1973, forward the case to a magistrate having jurisdiction to try the same, and the magistrate to whom any such case is forwarded shall proceed to hear the complaint against the accused as if the case has been forwarded to him under Section 376 of the Code of the Criminal Procedure 1973. Then every proceedings before the commission shall be deemed to be a judicial proceedings within the meaning of the Section 193 and 228. And for the purpose of Section 196 of the Indian Penal Code, and the commission shall be deemed to be a civil court for all the purposes of Section 195 and Chapter 26 of the Code of Criminal Procedure 1973. And Para 6 reads that where the commission considers it necessary or expedient so to do, it may by order transfer any complaint filed or pending before it to the state commission or the state from which the complaint arises for disposal in accordance with the provisions of this act. Then provided that no such complaints shall be transferred under the same age on respecting which the state commission has jurisdiction to entertain the same. Para 7 state that every complaint transferred under subsection 6 shall be dealt with and disposed of by the state commission as if it were a complaint initially filed before it. Para 14 refers about investigations. Number 1. The commission may, for the purpose of conducting any investigation pertaining to the inquiry, utilize the services of any officer or investigation agency of the central government or any state government with the concurrence of the central government or the state government, as the case may be. So let's look after the investigations. The commission may, for the purpose of conducting any investigation pertaining to the inquiry, that whether there were certain violations of the referred human rights, to utilize the service of any officer deputed to the commission or investigation agency of the central government that need to be impaneled with the NHRC for commencement of such inquiry, or any state government with the concurrence of the central government, like in acknowledgement of the central government that so and so agencies were annexed or deployed to commence investigation regarding violations of the human rights of the people, of the concurrence of the central government or the state government, as the case may be. Then investigative related para 2 states that for the purpose of investigating into any matter pertaining to inquiry, or any office or agency whose services are utilized under subsection 1 may, subject to the directions and control of the commission, like the related inquiry will be regulated by the commission, summon and enforce the attendance of any person and examine him. If some person related with investigation of the violations of human rights are associated, then they need to be summoned. Like if you are appearing in front of the commission as like a plaintiff, that there were certain violations of the human rights of the people, then like you are supposed to appear in front of the commission. You should attend the due process for hearing, and the related matters need to be examined. Then investigation includes like the discovery and production of any documents. Like I had submitted a lots of them, and there were like referred case details and diary open with respect to the submitted applications, that there were violations of the human rights of the people, and requisitions any public record or copy thereof from any office. Then the provisions of section 15 shall apply in relation to any statement made by a person before any officer or agency whose services are utilized under subsection 1, as they apply in relation to any statement made by a person in the course of giving evidence before the commission. Para 4 states that the officer or agency whose services are utilized under subsection 1 shall investigate into any matter pertaining to the inquiry and submit a report thereon to the commission within such periods as may be specified by the commission in this behalf. Para 5 states that the commission shall satisfy itself about the correctness of the facts stated and the conclusion, if any, arrived at in the report submitted to it under subsection 4, and for this purpose the commission may make such inquiry, including the examination of the person or persons who conducted or assisted in the investigation as it thinks fit. Then para 15 mentions about statement made by the person to the commission. Like no statement made by a person in the course of giving evidence before the commission shall subject him to or be used against him in any civil or criminal proceedings except prosecution for giving false evidence by such a statement. Like there are cross-checking and validations of the related things, and provided that the statement is made in reply to the question which is required by the commission to answer. The questions would be framed for a structured interview, like whether it is relevant to the subject matter of the inquiry. Then para 16 refers about persons likely to be prejudicially affected to be heard. Like if any stage of the inquiry, the commission may consider like it necessary to inquire into the conduct of any person, or is of the opinion that the reputation of any person is likely to be prejudicially affected by the inquiry, it shall give to that person a reasonable opportunity of being heard in the inquiry and to produce evidence in his defense. Or like you are associated with the inquiry, so if you need to be heard into that respective commission's hearing, then you can produce certain evidence or documents that you work for the defense of the human rights of the people to whom you are representing or to whom you are referring. Then provided that nothing in this section shall apply where the credit of a witness is being impeached. I would like to mention here an example that Swami Agnivesh filed PIL about abolition of the Sati Pratha. So he had produced related testimonies and arguments that on the basis of so and so submitted facts and arguments, such malfunctionings or like witchcraft should be abolished, and there should be protection of the life of the peoples being affected by like popularity of such what we can say superstitious practice of the society. Let's think about chapter 4 about procedures. Like paragraph 17 refers about inquiry into complaints. The commission, while inquiring into the complaints of violations of human rights, may, like number 1, call for information or report from the central government or any state government or any other authority or organization subordinate thereto within such time as may be specified by it. Then, provided that if the information or report is not received within the time stipulated by the commission, it may proceed to inquire into the complaints on its own, or it may extend the time. Like if on receipt of information or report the commission is satisfied either that no further inquiry is required or that the required action has to be initiated or taken by the concerned government or authority, it may not proceed with the complaints and inform that complaints accordingly. Para 2 refers that without prejudice to anything contained in clause 1, there are factors related with debate on the basis of prejudice, like if opponent express his perspective about the referred subject matter and the defendant presents his perspective with reference to the referred subject matter, because prejudice is the matter of debate and discussion. Like the referred advocate or the parties presents their own testimonies, their own statement, which is inclined by their own prejudice or the process of thinking, how they perceive about the referred subject matter, and it includes that further debates or cross questioning about the submitted facts or evidence or presented arguments, and cross questioning that whether the related facts were properly presented or there are certain imposition of personal intent of the person representing the subject matter. So it mentions that without prejudice to anything contained in the clause 1, if it consider necessary having regard to the nature of the complaint, initiate an inquiry. So the panels could further initiate the process, like there are so and so factors that need to be cross-examined. Para 18 states about steps during and after inquiry. Like the commission may take any of the following steps during or upon the completion of an inquiry held under this act, namely: A. Where the inquiry discloses the commission of violation of human rights or negligence in the prevention of violation of human rights or abatement thereof by a public servant, it may recommend to the concerned government or authority. Where A states that to make payment of compensation or damages to the complainants or to the victim or the member of his family, as the commission may consider necessary. Para 2 states that to initiate proceedings for prosecution of such other suitable actions as the commission may deem fit against the concerned persons or person. Para 3 states that to take such further action as it may think fit. Then Para B refers about the approach that Supreme Court or the High Court concerned for such directions, orders or rights as that court may deem necessary. 3 means that recommend to the concerned government or authority at any state of the inquiry for the grant of such immediate interim relief to the victims or the members of his family as the commission may consider necessary. So the related factor that first what kind of violations were committed against any person or the family members of the member or the party to the any case, then how the related factors need to be dealt. Further subject refers that it is subject to the provisions of clause provide a copy of the inquiry report to the petitioners or his representatives. Para E refers that the commission shall send a copy of its inquiry report together with its recommendations to the concerned government or authority, and the concerned government or authority shall, within a period of 1 month or such further time as the commission may allow, forward its comments on the report, including the action taken or proposed to be taken thereon to the commission. Let us discuss this. Like the commission shall send a copy of its inquiry report together with its recommendations to the concerned government or authority, and the concerned government or authority shall, within a period of 1 month or such further time as the commission may allow, forward its comments on the report, including the action taken or proposed to be taken thereon to the commission. Further narrative states that the commission shall publish its inquiry report together with the comments of the concerned government or authority, if any, and the action taken or proposed to be taken by the concerned government or authority on the recommendations of the commission. Para 19 refers that procedure with respect to armed forces. Section 1. Notwithstanding anything contained in this act while dealing with complaints of violations of human rights by member of the armed forces, the Commission shall adopt the following procedures, namely: A. It may either on its own motion or on receipt of a petition seek a report from the central government. B. After the receipt of the report, it may either not proceed with the complaints or, as the case may be, make its recommendations to that government. Then there are 2 states that the central government shall inform the Commission of the action taken on the recommendations within 3 months or such further time as the Commission may allow. Para 3 refers that the Commission shall publish its report together with its recommendations made to the central government and the action taken by the government on such recommendations. Para 4 refers that the Commission shall provide a copy of the report published under subsection 3 to the petitioner or his representative. Then para 20 refers that annual and special report of the Commission. 1. The Commission shall submit an annual report to the central government and to the state government concerned and may at time submit special reports on any matter which in its opinion is of such urgency or importance that it should not be deferred till submission of the annual report. Subpara 2 refers that the central government and the state government, as the case may be, shall cause the annual and special reports of the Commission to be laid before each house of the Parliament or the state legislature respectively, as the case may be, along with a memorandum of action taken or proposed to be taken on the recommendations of the Commission and the regions for non-acceptance of the recommendations, if any. Then Chapter 5 refers about the State Human Rights Commission. Para 21, Constitution of a State Human Rights Commission. Subsection 1 refers that a state government may constitute a body to be known as like the name of the state, Human Rights Commission, to exercise the powers conferred upon and to perform the functions assigned to a state government or state commission under this chapter. Then Para 2 state that the state commission shall, with effect from such date as the state government may be notification specify consist of a chairperson who has been a chief justice or a judge of a high court, or B, one member who is or has been a judge of high court or a district judge in the state with a minimum of 7 years of experience as district judge, or Para C, one member to be appointed from among persons having knowledge of or practical experience in matters relating to human rights. Para 3 refers that there shall be a secretary who shall be the chief executive officer of the state commission and shall, subject to control of the chairperson, exercise all administrative and financial powers of the state commission. Para 4 refers that the headquarters of the state commission shall be at such place as the state government may by notification specify. Para 5 refers that a state commission may inquire into violations of human rights only in respect of matter relatable to any of the entries enumerated in list 2 and list 3 of the 7th schedule of the Constitution. So the related discussions could also be included, like provided that if any such matter is already being inquired into by the commission or any other commission duly constituted under any law for the time being in force, the state commission shall not inquire into the said matter. Then provided further that in relation to the Jammu and Kashmir Human Rights Commission, this subsection shall have effect as it for the words and figure, list 2 and list 3 in the 7th schedule to the Constitution. The words and figures, list 3 in the 7th schedule of the Constitution, as applicable to the state of Jammu and Kashmir, and in respect of matter in relation to which the legislature of that state has power to make laws, has been substituted. Then 2 or more state government may, with the consent of a chairperson or member of a state commission, appoint such chairperson or, as the case may be, such member or another state commission simultaneously if such chairperson or member consents to such appointment, provided that every appointment made under this subsection shall be made after obtaining the recommendations of the committee referred to in subsection 1 of section 22 in respect of the state for which a common chairperson, a member, or both, as the case may be, is to be appointed. Section 7 refers that Subject to the provisions of Section 12, the central government may by order confer upon the State Commission the functions relating to human rights being discharged by the Union territories other than the Union territory of Delhi. Section 8 refers that the functions relating to human rights in case of Union territory of Delhi shall be dealt with by the Commission. Then appointment of chairperson and member of State Commission. Number 1. The chairperson and member shall be appointed by the government by warrant under his hand and seal, provided that every appointment under this subsection shall be made after obtaining the recommendations of a committee consisting of A. The Chief Minister, Chairperson, B. Speaker of the Legislative Assembly as member. Number 3. Minister in charge of the Department of Home in that state as member. D. Leader of the opposition in the Legislative Assembly as member. Provided further that where there is a legislative council in a state, the chairman of the council and the leader of the opposition in that council shall also be member of the committee. Provided also that no sitting judge of a high court or a sitting district judge shall be appointed except after constitution with the Chief Justice of the High Court of the concerned state. Then no appointment of a chairperson or a member of the State Commission shall be invalid merely by reason of any vacancy of any member in the committee referred to in subsection 1. Then 23 refers that resignation and removal of chairperson or a member of the State Commission. Para 1 refers that the chairperson or a member of a State Commission may by notice in writing under his hand addressed to the governor resign his office. Then it is subject to the provisions of subsection 2. The chairperson or any member of the State Commission shall only be removed from his office by order of the President of the Crown by the President on the ground of proved misbehavior or incapacity after the Supreme Court on a reference being made to it by the President. Has an inquiry held in accordance with procedure prescribed in that behalf by the Supreme Court, who reported that the chairpersons or such member, as the case may be, out on any such ground to be removed. Para 2 refers that, notwithstanding anything in subsection 1a, the President may be, by order, removed from office of the chairperson or any member if the chairperson or such member, as the case may be, like is adjourned as insolvent or engaged during his term of office in any paid employment outside the duties of his office, or is unfit to continue in office by reason of infirmity of mind or body, or is of unsound mind and stands so declared by a competent court, or is convicted and sentenced to imprisonment for an office which in the opinion of the President involves moral turpitude. Then term of office of chairperson and members of the State Commission. Like a person appointed a chairperson shall hold office for a term of 3 years from the date on which he enters upon his office or until he attains the age of 70 years, whichever is either, and shall be eligible for reappointment. Then a person appointed as a member shall hold office for a term of 3 years from the date on which he enters upon his office and shall be eligible for reappointment. Provided that no member shall hold office after he had attained the age of 70 years. Para 3 refers that on ceasing to hold office, a chairperson or a member shall be ineligible for further employment under the government of a state or under the government of India. Then member to act as chairperson or to discharge his functions in certain circumstances. Para 1 refers that in the event of the occurrence of any vacancy in the office of the chairperson by reason of his death, resignation, or otherwise, the governor may by notification authorize one of the members to act as the chairperson until the appointment of new chairperson to fill such vacancy. Para 2. When the chairperson is unable to discharge his functions owing to absence on leave or otherwise, such one of the members as the governor may by notification authorize in this behalf shall discharge the function of the chairperson until the date on which the chairperson resumes his duties. Then para 26 refers that terms and conditions of service of chairperson and members of the State Commission. like the salaries and allowance payable to and other terms and conditions of service of the chairperson and members shall be such a may be prescribed by the state government. Then it also provides that neither the salary and allowance nor the other terms and conditions of service of the chairperson or a member shall be varied to his disadvantage after his appointment. Para 27 refers that officers and other staff of the state commission the state government shall make available to the commission. A. An officer not below the rank of a secretary to the state government who shall be the secretary of the state commission. And B. Such police and investigative staff under an officer not below the rank of an inspector general of police, any such other officers and staff as may be necessary for the efficient performance of the functions of the state commission. Then it is subject to such rules as may be made by the state government in this behalf. The state commission may appoint such other administrative, technical, and scientific staffs as it may consider necessary. Para 3 refers that the salary, allowance, and conditions of the service of the officer and other staff appointed under subsection 2 shall be such as may be prescribed by the state government. Then about annual and special report of the state commission. The state commission shall submit an annual report to the state government and may at any time submit special reports on any matter which in its opinion is of such urgency or importance that it should not be deferred till submission of the annual report. The state government shall couch the annual and special reports of the state commission to be laid before each house of a state legislature where it consists of two houses, or where such legislature consists of one house, before that house, along with a memorandum of action taken or proposed to be taken on the recommendations of the state commission, and the reasons for non-acceptance of the recommendations, if any. Further, the applications of certain provisions relating to National Human Rights Commissions or State Commission, like the provision of Section 9, 10, 12, 13, 14, 15, 16, 17, and 18 shall apply to a state commission and shall have effect, subject to the following modifications, namely: A. Reference to commission shall be construed as reference to the state commission. B. In section 10, in subsection 3, for the word Secretary General, the word Secretary shall be substituted. C. In section 12, clause F shall be omitted. The related factors could be reviewed further. In section 17, in clause 1, the word central government or any shall be omitted. Then chapter 6 refers about human rights codes. So let us learn about this. The human rights codes, for the purpose of providing speedy trial of offence arising out of violations of human rights, the state government may, with the concurrence of the Chief Justice of the High Court, by notification, specify for each district a court or session to be a human rights court to try the said offences, provided that nothing in this section shall apply. If a court of section is already specified as a special court, or a special court is already constituted for such offences under any other law for the time being in force. Para 31 refers a special public prosecutor. For every human rights court, the state government shall, by notification, specify a public prosecutor or appoint an advocate who has been in practice as an advocate for not less than 7 years as a special public prosecutor for the purpose of conducting cases in that court. Then chapter 7 refers about finance, accounts and audits. Para 32 refers that grants by the central government. Para 1. The central government shall, after due appropriation made by Parliament by law in this behalf, pay to the Commission by way of grants such sums of money as the central government may think fit for being utilized for the purpose of this Act. Para 2 refers that the Commission may spend such sums as it thinks fit for performing the functions under this Act, and as such sums shall be treated as expenditure payable out of the grants referred to in subsection 1. Para 33 refers grants by the state government. Para 1. The state government shall, after due appropriation made by legislature by law in this behalf, pay to the state commission by way of grants such sums of money as the state government may think fit for being utilized for the purpose of this act. Subpara 2 refers that the State Commission may spend such sums as it thinks fit for performing the functions under Chapter 4, Chapter 5, and such sums shall be treated as expenditure payable out of the grants referred to in subsection 1. Para 34 refers accounts and audit. Subsection 1. The Commission shall maintain proper accounts and other relevant records and prepare an annual statement of accounts in such form as may be prescribed by the central government in consultation with the Controller and Auditor General of India. Subsection 2 refers that the accounts of the Commission shall be audited by the Controller and Auditor General at such intervals as may be specified by him, and any expenditure incurred in connection with such audit shall be payable by the Commission to the Controller and Auditor General. Subsection 3 refers that the Controller and Auditor General and any person appointed by him in connection with the audit of the accounts of the Commission under this Act shall have the same rights and privilege and the authority in connection with such audit as the Controller and Auditor General generally has in connection with the audit of government accounts, and in particular shall have the right to demand the production of books, accounts, connected vouchers and other documents and papers, and to inspect any of such offices of the Commission. Subpara 4 refers that the account of the Commission, as certified by the Comptroller and Auditor General or any other person appointed by him in this behalf, together with audit report thereon, shall be forwarded annually to the central government by the Commission, and the central government shall cause the audit report to be laid as soon as may be after it is received before each House of Parliament. Section 35 refers about accounts and audit of the State Commission. Subsection 1. The State Commission shall maintain proper accounts and other relevant records and prepare an annual statement of accounts in such form as may be prescribed by the state government in consultation with the Comptroller and Auditor General of India. Then subsection 2 refers that the accounts of the State Commission shall be audited by the Comptroller and Auditor General at such intervals as may be specified by him, and any expenditure incurred in connection with such audit shall be payable by the State Commission to the Comptroller and Auditor General. Subsection 3 refers that the Comptroller and Auditor General and any person appointed by him in connection with the audit of the accounts of the State Commission under this Act shall have the same rights and privilege and the authority in connection with such audit as the Comptroller and Auditor General generally has in connection with the audit of government accounts, and in particular shall have the right to demand the production of books, accounts, connected vouchers and other documents and paper, and to inspect any of the offices of the State Commission. Subsection 4 refers that the accounts of the State Commission as certified by the Comptroller and Auditor General or any other person appointed by him in this behalf, together with the audit report thereon, shall be forwarded annually to the State Government by the State Commission, and the State Government shall cause the audit report to be laid as soon as may be after it is received before the State Legislature. Chapter 8 refers about miscellaneous details like 36 matters not subject to jurisdiction of the Commission. Subsection 1. The Commission shall not inquire into any matter which is pending before a State Commission or any other commission duly constituted under any law for the time being in force. Subsection 2 refers that the Commission or the State Commission shall not inquire into any matter after the expiry of 1 year from the date on which the act constituting violations of human rights is alleged to have been committed. Then Section 37 refers that constitution of a special investigation terms, notwithstanding anything contained in any other law for the time being in force, where the government considers it necessary so to do. It may constitute one or more special investigation terms consisting of such police officers as it thinks necessary for purpose of investigation and prosecution of offences arising out of violations of human rights. So let us discuss this one. I think I just read it thoroughly. So let us discuss constitution of a special investigation team. So let us discuss like notwithstanding anything contained in any other law for the time being in force, where the government consider it necessary to do so, it may constitute one or more special investigation team. consisting of such police officers as it think necessary for purpose of investigation and prosecution of offence arising out of violation of human rights. Section 38 refers about protection of action taken in good faith, like no suit or other legal proceedings shall lie against the central government, state government, commission, the state commission or any member thereof or any person acting under the direction either of the central government, state government, commission or the state commission in respect of anything which is in good faith done or intended to be done in pursuance of this act or of any rules or any other made thereunder or in respect of the publication by or under the authority of the central government, state government, commission or the state commission of any report, paper or proceedings. Section 39 refers that members and officers to be public servants, like every member of the commission, state commission and every officer appointed or authorized by the commission or the state commission to exercise functions under this act shall be deemed to be a public servants within the meaning of section 21 of the Indian Penal Code 45 out of 1860. Then about powers of central government to make rules. Para 1. The central government may be by notification make rules to carry out the provisions of this act. Subsection 2 refers that in particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely A. The salaries and allowance and other terms and conditions of the service of the chairperson and members under section 8. The conditions subject to which other administrative, technical and scientific staff may be appointed by the commission and the salaries and allowances of the officers and other staff under subsection 3 of section 11. C. Any other power of a civil court required to be prescribed under clause F of subsection 1 of section 30. D. The form in which the annual statement of account is to be prepared by the commission under subsection 1 of section 34. And E. Any other matter which has to be or may be prescribed. 3. Every rule made under this act shall be laid as soon as may be after it is made before each house of parliament. So the related rules or the hearings associated factors need to be produced into the parliament. Like every rule made under this act shall be laid as soon as may be after it is made before each house of parliament while it is in session for a total period of 30 days, which may be comprised in one section or in two or more successive sessions, and if before the expiry of the session immediately following the session or the successive sections aforesaid both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form or be of no effect as the case may be. So however that any such modifications or annulment shall be without prejudice to the validity of anything previously done under that rules. Then para 40A, power to make rules retrospectively. The power to make rules under clause B of subsection 2 of section 40 shall include the power to make such rules or any of them retrospectively from a date not earlier than the date on which this act received the assent of the President, but no such retrospective effort shall be given to any such rule so as to prejudicially affect the interest of any person to whom such rule may be applicable. Then 40B, power of commission to make regulations. Subject to the provisions of this act and the rules made thereunder, the commission may, with the previous approval of the central government, by notification make regulations to carry out the provisions of this act. So, in particular and without prejudice to the generality of the foregoing power, such regulations may provide for all or any of the following matters, namely A. The procedure to be followed by the Commission under subsection 2 of section 10. B. The return and statistics to be furnished by the State Commission. C. Any other matter which has to be or may be specified by regulations. 3. Every regulations made by the Commission under this Act shall be laid as soon as may be after it is made before each House of Parliament, while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions, and if before the expiry of the session or the successive session aforesaid, both houses agree in making any modifications in the regulations or both houses agree that the regulations should not be made. The regulations shall thereafter have effect only in such modified form or be of no effect, as the case may be. So, however, that any such modifications or annulment shall be without prejudice to the validity of anything previously done under that regulation. Para 41 refers that power of a state government to make rules. Subsection 1. The state government may be notification make rules to carry out the provisions of this act. Subsection 2. In particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely A. The salaries and allowance and other terms and conditions of service of the chairperson and members under Section 26. B. The conditions subject to which other administrative, technical, and scientific staff may be appointed by the State Commission, and the salaries and allowance of the officers and other staff under subsection 3 of Section 27. C. The form in which the annual statement of accounts is to be prepared under the subsection 1 of Section 35. C. Every rule made by the state government under this section shall be laid as soon as may be after it is made before each house of the state legislature where it consists of two houses, or where such legislature consists of one house before the house. 42. Power to remove difficulties. A. If any difficulties arise in giving effect to the provisions of this Act, the central government may, by order published in the official gazette, make such provisions not inconsistent with the provisions of this Act as appear or it to be necessary or expedient for removing the difficulty, provided that no such order shall be made after the expiry of the period of 2 years from the date of commencement of this Act. 2. Every order made under this section shall, as soon as may be after it is made, be laid before each House of the Parliament. Then 43. Repeal and savings. Subsection 1. The Protection of Human Rights Ordinance 1993 is hereby repealed. Repeal means like repealed or cancelled. But on which basis, on which things? Let us discuss about things like notwithstanding such repeal, anything done or any action taken under the said ordinance shall be deemed to have been done or taken under the corresponding provisions of this Act. So there are factors related with its repealing or its reinforcement, its amendment. Let us read it once again. Repeal and saving, Section 1. The Protection of the Human Rights Ordinance 1993 is hereby repealed. Like how it could be repealed. Then Section 2. Notwithstanding such repeal, anything done or any action taken under the said ordinance shall be deemed to have been done or taken under the corresponding provisions of this Act. So in this way, this is the first draft of the NHRC rules, and it need to be followed while performing the due process of protection of the human right of the people. Thank you.